All rise, please. Court's back in session.
Thank you. Have a seat. Thank you.
Could I address something that happened this morning?
Yeah.
We had two cases. One of them was, and I've talked to the clerk, was Shannon Gallardo in case 2020 CF 128 and 24 CF 545. I think it was the court's intention to revoke him and put him on a new period of supervision, but the clerks didn't hear that, and it's not on the minute sheet. But I think that was the intent.
There's no objection, Judge.
All right. That's what we'll do.
And the last one, I stood up and said something on a Kevin Bray. His case is 23 CF 2408 and 2409. And I referenced he needed to be on GPS because he had previously been on GPS for
All right.
a qualifying offense. That period has run out, and it was a condition of his conditional release that we had him on GPS. So now he does not have to be on GPS,
All
and
right.
we need the minutes to reflect that GPS does not need to be attached prior to release.
You got that, Miss Anna? Okay, thank you.
Thank you, Your Honor. Sorry about that.
All right, we're here for 130 arraignments. When I call your name, come up to the front here, this podium. Each of you will be told what your charges are, asked if you want to retain your own attorney or you have the right to a public defender if you cannot afford an attorney, and I'll be happy to appoint you an attorney. Each of you have the right to remain silent. You have the right to know the charges against you. You have the right to an attorney, right to a jury trial. You'll probably be pled not guilty today, and a court date will be set, although many of you may be offered a deal by the state today, which will take care of your case. So we'll see if that happens when I call your name. The first case I have is Sheraton Abram.
Your Honor, Tim Gibbs on behalf of Sheraton Abram. Judge, this is 24 CF 1787. Judge, Ms. Abram is present and approaching. We will enter a plea of not guilty. Over here, Ms. Abram. We will enter a plea of not guilty, request 15 days for any pre-arraignment motions, and demand trial by jury. And that's
Charged with felony petty theft and burglary of an unoccupied structure. So he's pled you not guilty. We'll see you, what day? October 28th.
October 28th.
October
is our next
28th.
Pre-trial, yes, thank you.
Thank you.
Okay, give me a call.
James Woodward Allen.
Your Honor, Tim Gibbs on behalf of Mr. James Allen. Judge, this is 24 CF, if I can find the correct case number on here. 24 CF 1668. Judge will enter a plea of not guilty, request 15 days for any pre-arraignment motions, and demand trial by jury. He's got some other cases that we'll be trying to work out.
All right,
as well.
Mr. Allen, charged with dealing in stolen property. See you October 28th. Thank you.
But I'll see you before then. Yeah.
Jeremy Altman.
Jeremy Ottman. Sounded earlier with no response, Judge.
State asked for a capias.
No bond capias. So if you don't show up for court, that means I issue an arrest warrant and you get to sit in jail for a while. Shante Booker.
Your Honor, Tim Gibbs on behalf of DeShanti Booker. Judge, this is 24 CF 1770. We'll enter a plea of not guilty, request 15 days for pre-arraignment motions, and demand trial by jury. That's your copy of the charges.
Mr. Booker, you're charged with burglary with assault, ag battery, victim pregnant, and tampering and felony. So we'll see you October 28th.
Thank you,
Okay.
Judge. No, you're good. Go ahead and give me a call to make an appointment.
Jerry Lee Bowman.
Yes, it was.
Merton Scott Brayley.
Your Honor, Tim Gibbs on behalf of Merton Braley. Judge, this is 24 CF 1659. Your Honor, will enter a not guilty plea, request 15 days for any pre-arraignment motions, and demand trial by jury. So we weren't able to get
All right, Mr. Braley, you're charged with smuggling contraband into a prison, possession of a controlled substance without prescription, resisting an officer without violence, possession of narcotics equipment. You've been pled not guilty. See you October 28th.
Thank you, Judge. Yeah, but I'll see you before then. We'll move you up if we can.
Lewis Campbell, or excuse me, Terry Louise Campbell. Terry Campbell. No bond, capias. Melinda Carroll.
Oh, yeah. Told you that.
All right, Ms. Carroll, you're charged with writing a check insufficient funds, third-degree felony. Is there an offer from the state?
The state's initial offer is going to be a pretrial intervention agreement. So if she gets an attorney, we can hash it out.
All right, I'm going to appoint the public defender to represent you. What a pretrial intervention agreement means, if you can come to an agreement with the state on doing certain things, like pay the money, do some counseling or something, they'll drop the charges. Okay?
Judge, we'll enter a not guilty plea then. Let's leave her set for the 26th, September 26th work.
I'll appoint public defender.
Yeah, thank you, Judge.
James Earl Carter. Is James Earl Carter Jr. here? No bond, capias.
Is that your honor? I'm sorry.
James Earl Carter.
Christopher Dwight Cole.
Good afternoon, Your Honor. Tim Gibbs on behalf of Mr. Christopher Cole. Judge, this is 24 CF 1637. Tim Gibbs from Public Defender's Office. Your Honor, Mr. Cole is present. We'll enter a plea of not guilty, demand trial by jury, and request 15 days for any pre-arraignment motions.
All
Here's
right.
your copy.
Mr. Cole, you're charged with possession of controlled substance without prescription and possession of narcotics equipment. We'll see you October 28th.
Thank you, Judge. Make an
Thank you.
appointment.
Timothy Jacob Kami.
Your Honor, Tim Gibbs on behalf of Timothy Comey. Judge, this is 24 CF 1657. Your Honor, we'll enter a plea of not guilty, request 15 days for pre-arraignment motions, and demand trial by jury. That's your copy, so.
All right, Mr. Kami, you are charged with displaying a firearm during a felony, fraudulent impersonation of another person, 2 counts, fleeing and attempting to elude with sirens activated, and petty theft. See you October 28th.
All right, thank you, Judge.
Lana Shawn Creech.
Your Honor, Tim Gibbs on behalf of Ms. Lana Creech. Judge, this is 24 CF 1619. Over here, Ms. Creech. Your Honor, we'll enter a not guilty plea, request 15 days for pre-arraignment motions, and demand trial by jury. So we weren't.
Ms. Creech, you're charged with possession of controlled substance without prescription, destroying evidence. See you October 28th.
Oh, yeah. I'll be able to visit you in the next couple of weeks.
Tracy Lynn Daniel.
I'll be able to come talk to you.
Ms. Daniel, you're charged with aggravated assault with a deadly weapon without intent to kill. Is there an offer for her?
Yes, Judge. The offer in this case is going to be a lesser included offense. It's going to be a reckless driving. The sentence that the state's offering is a withhold of adjudication, 18 months of probation, 967 court costs, no contact with the victims, and your management course. And I would like to correct my sentence. It would be 12 months probation since it's a misdemeanor.
What they're offering is to reduce the charges down to a misdemeanor. Withhold adjudication, that means you won't have an actual conviction. 12 months probation, 967 court costs, have an anger management course, and what else was it?
Then no contact with the victim.
No contact with the victim. And standard court, 967 court costs. You don't have to do that if you don't want to, but do you want to take that? Get it done today, except for your probation? Right now, you're looking at a third-degree felony, reducing it down to a misdemeanor.
Yeah, I would do that, Your Honor.
You do? Okay. This is 24 CF 1727, State of Florida versus Tracy Lynn Daniel. Ms. Daniel, please raise your right hand and be sworn. Swear the testimony you give for his court's truth, so help you God. You want to enter a no contest plea to charge of reckless driving, a misdemeanor, and a lesser included offense of aggravated assault with a deadly weapon without intent to kill, correct? You understand the rights you're waiving by entering this plea, your right to a jury trial, right to an attorney, right to remain silent, right to make the state prove its case beyond a reasonable doubt, and other rights too. But you understand you're waiving all your rights? Has anyone forced you or threatened you to enter this plea?
No,
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the plea is freely and voluntarily entered. Court accepts it, withholds adjudication, sentences you to 12 months probation. 967 court costs, have an anger management class, no contact with the victim. Okay? There's probation right over there.
thank you.
I'll waive cost of supervision. We did De La Rosa this morning, or this afternoon, right?
Yes, Your Honor.
Richard Luis Del Pozo.
Your Honor, Tim Gibbs on behalf of Mr. Richard Del Pozo. Judge, this is 24 CF 1670. Your Honor, we'll enter a plea of not guilty and leave this set for pretrial. Request 15 days for any pre-arraignment motions and demand trial by jury. So this is, you copy.
Right, you're charged with burglary of a dwelling and grand theft. We'll see you October 28th.
Thank you, Judge. October 28th. October 28th, but we'll move. I'll move it. Yeah, here, this is your copy. I'll come see you. Here, I'll take that. Sure.
Keem Dixon.
Your Honor, I was appointed to Mr. Dixon's VOP cases. I don't think I was actually appointed to this new law case. So I just wanted to bring that to the court.
Charged with possession of a controlled substance without prescription. I'll appoint the public defender.
Thank you, Judge. We'll plead not guilty. I don't remember off the top of my head when his next VOP date is. I'd like to track everything together.
October 31st, I think.
That's fine, Judge. And if we can move him up, we will. Are you set for next week?
Yeah, we moved it to the 5th.
Judge, I think his VOP set for next week?
For the 5th.
Looks like they're set for,
September
Okay,
5th.
I'd like to track it all September 5th then.
All right, good, September 5th.
Thank you, Judge. I got your letters.
Joshua Adam Douglas.
Your Honor, Tim Gibbs on behalf of Joshua Douglas, 24 CF 1670.
Mr. Douglas, you're charged with fleeing and attempting to elude, drug possession without a prescription, suspended driver's license, and resisting an officer without violence. Okay?
Judge, we'll enter a not guilty plea today. I'd also like to track him to next Thursday on the 5th to see if there's bond issues we can work out.
September 5th, thank you.
Judge. Thank you. That's a copy of yours. That's your copy of the new charges.
Is it Jashaw Fagan? Jashaw?
Mr. Fagan?
Jashaw James Fagan?
How do you pronounce your first name, sir? Joshua. Your Honor, Tim Gibbs on behalf of Joshua Fagan. Judge, this is 24 CF 1696. Will enter a plea of not guilty. Request 15 days for any pre-arraignment motions. Demand trial by jury and leave this set for pretrial.
All right, you're charged with child neglect without great bodily harm, October 28th.
Thank you, Judge. All right, give me a call.
Stanley James Forett.
Your Honor, Tim Gibbs on behalf of Mr. Forett. Judge, this is 24 CF 1591. Over here, Mr. Forett. I think the state has an offer they'd like to convey.
I do have an offer. It's going to be an adjudication of guilt, 515 court costs, and just credit for time served. No probation, no jail.
I don't have it written up, but he does want to accept that offer, Judge.
All right,
This is your copy.
this is to a felony
Felony petty theft, Your Honor.
adjudicated.
Adjudicated 515 in costs. Was there any restitution, Mr. Sprouse?
No restitution owed. The victim got his.
Mr. Forett, would you please raise your right hand to be sworn? You swear the testimony you give for us court's true, so help you God.
Yes, sir.
You want to enter a no contest plea to felony petty theft, second or more conviction, correct?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you $515 court costs. No jail or probation. Court orders you not to break the law in the future. Thank you.
I believe the court also has to impose the public defender fee in that case, too.
What is it, $100?
150 total.
$150. Thank you. Yeah.
So you get that paid as soon as you can. You're good to go. Oh, I'm sorry. Yeah, he needs to get your fingerprints. I'm sorry. Thank you.
Miss Rivers smiles every time I order these people not to violate the law in the future. But they listen to me.
We like to think so, for sure.
Jarlee Frazier.
Your Honor, Tim Gibbs on behalf of Ms. Jara Frazier. Judge, this is 24 CF 1634. Ms. Frazier is present and approaching. Your Honor, will enter a not guilty plea. Request 15 days for any pre-arraignment motions. Demand trial by jury and leave this set for pretrial.
Ms. Frazier charged with 14 counts of animal cruelty. We'll see you October 28th.
Give me a call. Thank you, Judge.
Bradley Charles Gasway. Nikki Lee Grimes.
Your Honor, Tim Gibbs on behalf of Ms. Nikki Grimes. Judge, this is 24 CF 1776. Ms. Grimes is present and approaching. Your Honor, we will enter a plea of not guilty, request 15 days for pre-arraignment motions, and demand trial by jury. Over here, Ms. Grimes. Demand trial by jury and leave this set for pretrial.
And Ms. Grimes, you're charged with resisting an officer with violence, battery on an officer, drug possession without a prescription, narcotics equipment possession, petty theft of merchandise. See you October 28th.
Thank you, Judge.
Jarlib Hagens. It's 23 CF 2295. Mr. Hagens, you're charged with possession of a weapon by a convicted felon, trespassing, property armed, and loitering and prowling. Is there an offer for him?
He's represented by Mr. Williams.
Okay.
There is, Judge, I did not have, the offers for a 3-year mandatory minimum, so we'll
All
be
right.
entering a plea of not guilty.
October 28th. Thank you, sir.
Thank you.
Richard Thomas Hand.
We did it this morning.
McKinney Perez Harris.
Judge, that's going down to county court.
Jeffrey Dwayne Holland.
That's a fugitive from justice, Your Honor.
And a false ID, that's going to county court.
Destiny Hurley.
Ms. Hurley, there you go. Does the state have an offer for Ms. Hurley?
1 second.
Ms. Hurley, you're charged with obstruction of justice and domestic violence battery.
Bear with me. Let's see.
I tell you what, since DV battery has sanctions that can live on with regard to federal firearms issues, let's just have her come in and meet with me. Judge, I'll just enter a plea of not guilty on her behalf. Ma'am, come by the office, call and make an appointment, come and we'll talk about your case, okay?
October 28th. Thank you. Kelly Lee Hutto.
Judge, Mr. Hutto was passed from this morning. The state did send discovery over about 11:30, and I've met with Mr. Hutto back in lockup. Here you go, sir. Thank you. Judge, I'm just going to enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions and trial by jury.
All right, you're charged with possession of controlled substance without prescription, driving license suspended or revoked, possession of narcotics equipment, possession of a catalytic converter, and without ownership, and fleeing, attempting to elude. We'll see you October 28th. Thank you.
Thank you, Judge.
Oh, yeah, because.
Destiny Jackson,
Took care of that one.
Paul Johnson,
No cost was filed.
Nathaniel Paul Jones,
Jones, Nathaniel.
Hey, Mr. Jones, come stand over here. Judge, I'm going to enter a plea of not guilty on Mr. Jones's behalf, request 15 days for any pre-arraignment motions and trial by jury.
Mr. Jones, you're charged with aggravated battery. See you October 28th. Thank you.
That's it. So, I tell you what, nope, that's not it. Here, this is actually your copy. There you go.
Robert Jones,
Robert Jones.
Judge, on Mr. Jones, I'm going to enter a plea of not guilty and request 15 days for pre-arraignment motions and trial by jury. Judge, we might want to schedule a pretrial conference on it. I don't think it's properly charged. I don't know, though, if we want to wait until a JOA or go ahead and have a motion to dismiss on it.
Yeah, feed me.
he's charged with criminal mischief.
Yes, sir. He's charged with criminal mischief as a recidivist. If the court will look at the case number that they're using, particularly the two letters in the middle.
Not too fat for this.
What am I supposed to be looking for?
Be talking right now.
What am I looking?
He would have to file a motion, Your Honor, nothing at this time.
All right, well, y'all file a motion instead of
All
hearing.
right, so I can go ahead and file under 12, like 12B, or,
Yeah, I told you I was gonna give you a misdemeanor criminal mischief anyway.
okay.
Sound like they're gonna reduce the charges down to a misdemeanor, so
I'm
whatever.
glad you understand that.
Well, we'll see you. See you at a hearing. Thank you.
Well, one thing I needed to have cleared up just got cleared up.
Pardon?
Nothing, Judge, a relevant mark on my part.
Desmond Jordan.
Out of state fugitive, I assume he's
I filed a no cross.
Savannah Kier. Charged with possession of controlled substance without a prescription, possession of narcotics equipment.
Does the state have an offer for Ms. Kier?
Ms. Kier was here, I believe, Monday, so she definitely wants to get this resolved. That's what it seems like. So the offer's a withhold of adjudication, 615 court costs, no probation, no jail.
Hey, you want to do that? Please raise your right hand to be sworn. You swear the testimony you give for is course of truth, so help you God.
Yes.
You want to enter a no contest plea to possession of controlled substance without prescription, possession of narcotics equipment, third-degree felony, and a first-degree misdemeanor. Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Court finds the plea is freely and voluntarily entered. Court accepts it, withholds adjudications, no probation or jail time, 615 court costs, and I'll give you 90 days to pay it before it goes to collections. Okay?
Yes, sir.
She's trying to give herself probation.
Or jail. She walked towards the jail first.
Nobody wants to go that way.
Yeah, don't go that way.
Timothy Brian Kimmons,
We did.
George Ivan King, Mr. King, you're charged with possession of controlled substance without a prescription.
Judge, the offer in this case is an adjudication, credit for time served, 615 court costs, and we do have an FDLE report back already, positive.
What they're offering is, if you want to enter a no contest plea to this, I'll sentence you for credit for time served. In other words, no more jail time, no probation, 615 court costs. You'll be adjudicated a felon, though. You want that?
A felon, you said?
No probation, no more jail time.
How long would I have to pay it?
I'll give you 90 days to pay it before it goes to collections.
I can do that.
Have you been adjudicated a felony before? You have, so it ain't gonna make any, would you raise your right hand to be sworn? This is George Ivan King, 24 CF 1624. Mr. King, you swear the testimony you give for is court's truth, so help you God.
I do.
You want to enter a no contest plea to possession of drugs without a prescription, a third-degree felony, correct? Has anyone forced you or threatened you to enter this plea? Are you aware of the rights you're waiving by entering this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? And court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sends you to time served in the county jail, 615 court costs, 90 days to pay it before it goes to collections.
Thank you.
Okay? Thank you. Lisa Kramer. Ms. Kramer is charged with battery on a person in a detention facility, 2 counts.
Okay, Ms. Kramer, this isn't a trial of any sort today. remember I talked to you, I'm going to enter a plea of not guilty on your behalf, request 15 days, and have somebody come out and talk to you. No, 15 days for me to file pre-arraignment motions, okay? Okay. Judge, I'm going to have somebody come out.
October 28th.
Thank you, Judge.
Thank you. I'll get that resolved. We can move that up. I mean, you know.
I'll work on it, Judge.
At the appropriate time, ma'am. Oh, here, Ms. Kramer, here. You can have it.
Christopher Krivik. Mr. Krivik, you're charged with trafficking in fentanyl and trafficking in meth.
Perfect, come stand right over here. Go to that sure copy.
24 CF 1648.
Judge, I'll be entering a plea of not guilty, request trial by jury, and 15 days for any pre-arraignment motions. The charge is a trafficking in fentanyl, first-degree felony, and another first-degree felony trafficking in amphetamine or methamphetamine.
October 28th.
Thank you, Judge.
Nick Williams, likely.
Hey, you need to make an appointment to come see me. Okay? You take this.
Mr. Likely is charged with aggravated assault with a deadly weapon without intent to kill. Is there an offer for Mr. Likely?
Yes, Judge, the offer is an adjudication of guilt, 38 months DOC, 967 court cost.
Appoint the public defender. Appoint the public defender.
Yes, sir. I'm just going to get some information off this sheet here. Judge, I'm going to enter a plea of not guilty, request 15 days for pre-arraignment motions, and trial by jury.
See, October 28th.
I'll explain it to you later.
38 months, DOC.
Yeah. That's state prison. You don't want to go to state prison today, do you?
Just got out of prison.
Tell you what, have a seat out there. I'll come talk to you in just a minute, okay? Oh, yeah, they're going to have to get DNA from you all.
Joseph Michael Lawley.
Judge, I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions and trial by jury.
Mr. Lawley, in charge of burglary of an unoccupied dwelling, unarmed, and grand theft. See you October 28th.
Sir, that's your copy, okay? Call me, appointment, come see.
Kelsey Murphy. Matthew Murphy.
You're Matthew David?
Yes, sir.
Charged with criminal mischief.
Yes, sir. We're negotiating on this case. I think I might have something worked out, but I think the state needs a little more time on it. This is the one I sent you the email talking about maybe PTI or something like that.
Okay.
October 28th. Move it up if you can get it resolved. Christopher Corey Murray.
Have a seat out there. I've got just a couple more names to call, and I'll go over it all again with you, okay? Okay.
Christopher Corey Murray. Charged with smuggling contraband and possession of cocaine.
Your copy. Sir, they've got an offer for you that would be 12 months probation or probation. It does have a curfew. Do you want to do Judge, I'll enter a plea of not guilty, request 15 days for pre-arraignment motions and trial by jury.
See you October 28th. Amand Robinson,
Your Honor, we handled that this morning.
Courtney Rose,
Your Honor, my understanding is the public defender was just appointed on this matter. Ms. Rose is present. We are going to enter a not guilty plea and request a trial by jury with a October 28th court date.
charged with illegal use of a credit card and impersonating a possession with ID of another person. October 28th. Thomas Schemelzy. Charged with possession of ammo or a weapon by a convicted felon, possession of controlled substance without prescription, operating a motor vehicle without a valid license, attached license plate with not assigned, and fraudulent use of ID of another person.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
October 28th. Thank you. Johnny Stallworth. Charged with felony battery.
Your Honor, I was appointed to represent Mr. Stallworth on one of his other cases. I would request appointment at this time on this case as well.
Point to PD.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
October 28th. Thank you.
There is another charge that's coming down. I'm sure the defense is aware. It's an aggravated stalking case. He was recently released from jail, or I believe it was jail. So once that case gets filed on, the state's going to seek PRR, and it's a minimum of 5 years DOC. Right now, to resolve both cases, I would dismiss the aggravated stalking for a plea to this charge for 24 months DOC.
You want to bring him back September 5th to see if he wants to do that?
If I could get some more information. Yes, sir.
I'll get what information we need.
Okay, it's something to consider, okay? They might dismiss some charges and get rid of a minimum mandatory and all that, so let Ms. Rivers get with you. We'll bring you back September 5th, see if you want to do it. You don't have to, but you may want to, okay?
Yes, sir.
Thank you. Ralph Thompson. No bond capias. Robert Wade Thompson. Charged with driving license suspended with prior convictions.
Your Honor, I did convey the state's offer to him, which was to plead to a misdemeanor for court costs. I believe he does want to take that.
Mr. Thompson, would you please raise your right hand to be sworn? You swear the testimony you give for is court's truth, so help you God.
Yes, sir.
All right, you want to plead to a, is it reduced down to a misdemeanor driving license suspended or something? Okay. Is that with an adjudication or with it?
It'd be an adjudication, 300 court costs, I believe.
300?
Yes.
So you want to enter a no contest plea to that misdemeanor?
Yes, sir.
You aware the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty, sentence you to pay $300 court costs. Give you 90 days to do it before it goes to collections.
Yes, sir. Thank you.
Okay? Thank you. Adjudicated guilty. As a misdemeanor, okay? Thank you. Montana Wurlitz. Charged with battery, contempt of court, violation of an injunction by domestic cruelty towards a child without great bodily harm and obstruction of justice. Is there an offer?
It will ultimately be a probation officer, but it will involve some such conditions.
All right, I'll appoint the
Discuss.
public defender and see you, I guess you're going to plead or not guilty,
Yes, Your Honor.
October 28th.
Okay. If you give me a few minutes, I'll talk to you about it.
Sabrina Williams. Charged with robbery and battery on a person over 65,
Your Honor,
65 or older.
we're entering a not guilty plea and request trial by jury.
October 28th. Thank you. Is that it on our arraignments?
I have Ms. Cannon from this morning, Judge.
Is who?
Tiffany Cannon, we had the written plea agreement.
All right, come on up. Who is this?
James Carter. Uh-oh.
Have a seat. We'll get with you in just 1 second.
Your Honor, we're back on the record again with Ms. Cannon. Judge, this is 24 CF 933, adding in 24 CT 1565, 24 CT 1602. The court wanted to make sure that Judge Ward had no objections to the court taking her plea in the county court. I did get that in writing from Judge Ward, if I may.
All right. It seemed to indicate that Judge Ward doesn't care if we resolve all the misdemeanor cases in the future. That's the way it looks to me.
That's how it read to me as well, Your Honor.
All right, this is State of Florida versus Tiffany Cannon, 24 CF 933, 24 CT 1565, and 24 CT 1602. Ms. Cannon, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, sir.
You want to enter a no contest plea to the charge of is she going to plead to aggravated battery with deadly weapon, a second-degree felony?
Yes, Your Honor.
That's in 24 CF 933 and 24 CT 1565, pleading no contest to DUI with property damage. And in 24 CT 1602, leaving scene of an accident, count 1, and reckless driving, count 2. So you want to enter no contest plea to those charges, correct?
Yes, sir.
Court, did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone enforce you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
On 24 CT 1565, the DUI, the court's going to sentence you to 11 months, 29 days probation, $500 fine, $463 court costs, $100 PD fee, DUI school, 50 hours community service, victim impact panel, 6 months driver license suspended, 10-day vehicle impound, reserved jurisdiction on restitution, and all requirements may transfer to 24 CF 933 upon termination. And this sentence is concurrent with 24 CF 933. You're also adjudicated guilty on that case. In 24 CF 933, sentenced to 3 years probation.
Sorry, Your Honor, it's a withhold adjudication in 24 CF 933. The only adjudicated guilty count is the DUI.
I was going to get to that in just a
Okay,
second.
I'm sorry. I thought you had said that she was adjudicated guilty on the felony as well.
No. If I did, I didn't mean that, but
Thank you, Judge.
24 CF 933, sentenced to 3 years probation, $100 cost of prosecution, $667 court cost, $150 PD fee, 100 hours community service. No contact with Jonathan Cannon may be modified at victim's request in writing. Take a batter's intervention program. No trespassing at Jonathan Cannon's residence or place of employment, and that is withhold adjudication. And the sentence runs concurrent with 24 CT 1565. In 24 CT 1602, this is concurrent with the other cases. Sentenced to 6 months probation, standard court costs, $100 PD fee, reserved jurisdiction restitution. All requirements may transfer to 24 CF 933 upon termination and withhold adjudication on this.
Thank you, Your Honor. Fingerprints?
We request the supervision fees be waived, Your Honor.
Okay.
Thank you, Your
She
Honor.
has the entire period, she has the entire 3 years in which to complete these conditions, is that correct?
Yes.
Otherwise, Judge, the only other one that I had on the dockets today was Mr. Shane Collier at 2 p.m. It's set for an evidentiary hearing. I believe he should be prepared to enter a plea to the bench and reset sentencing for a later date.
All right. Shane Collier, where is he?
He's in jail, Your Honor. They're working on bringing him out.
We have witnesses here for Collier.
I do not. I don't know if the state did, but we're intending.
I have
we're
probation
intending to
officer
plea of some kind.
Kalogli. He's ready.
Who?
Probation
Kalogli.
officer.
Aaron?
Yeah, Aaron.
One of our probation officers.
Yes, Your Honor.
Okay, well.
He wants to testify.
You want to testify or you want me to take a plea?
I'll leave that discretion to the court. I did study.
Oh, what about this gentleman back here in the back? We'll get you next, okay? Was it Carter? Okay, we'll get you next.
Your Honor, Tim Gibbs on behalf of Mr. Shane Collier. Judge, this is 22 CF 663, 22 CF 665, 22 CF 2690, and 23 CF 1917. Your Honor, these are all violations of community control. He is set for an evidentiary hearing this afternoon. We would like to enter an admission to the bench and reset sentencing for September 26th. We're working on getting him into drug court. He's going to be interviewed on Tuesday by Ms. Henderson.
All right, so he's entering an admission of violation of community control on all these cases?
Yes, Your Honor.
Mr. Collier, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
You want to admit that you violated community control on all these cases?
Yes, sir.
Has anyone forced you, threatened you to enter this admission?
No, sir.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
You understand, apparently, there's no plea agreement between the state and the defense, and I could give you whatever legal sentence I feel like is appropriate for this admission. Court finds admission freely and voluntarily entered. Court accepts it. Was set it for what, September 26th?
That's what I'm asking, Judge.
Okay, maybe you can get in, what is it, drug court?
We'll have him evaluated for drug
All
court
right,
and
we'll
see
see
if
what
that's
we
an
can
option
do.
for the court. Either one works for me.
We'll do it 9. If we can't get it done 9, we'll do it at 2.
Thank you, Judge.
Okay? All right. Is
Thank
it
you, Your
Carter, Mr. Carter? What's your first name, Mr. Carter? James.
Sir.
Was he supposed to be here this morning?
Yes, sir.
He was here for plea day
All right, has he got an attorney?
No, sir.
What's he charged with?
Um,
I don't have my docket for this morning with me.
Possession of firearm and ammo
by ammunition, yes, sir, and possession of a controlled substance.
All right, let me appoint a public defender to represent you, okay?
Okay.
Your Honor, we'll enter a plea of not guilty, request 15 days for any pre-arraignment motions, and demand trial by jury. We'll leave this set for pretrial October 28th.
All right, get with Mr. Gibbs and work on your case.
Yes, sir.
Thank you.
Thank you.
Oh, Mr. Carter,
Just give you a phone call. We'll work it out.
Mr. Carter, why weren't you here this morning?
I was running late. I'm from Louisiana.
Oh,
He was on the 1:30
Just got
docket,
off of work.
Judge.
okay, I'll recall the capias,
Thank you, Judge.
Okay.
okay?
Give me a call.
Now we've got, we have anyone else with a plea?
We have Canfield, Judge.
Mr. Canfield gonna plead?
Yes, Your Honor.
Okay.
Judge Tim Shaw for William Riley Canfield, Jr. We have three case numbers on the docket, 23 CF 2442, 2005 CF 1029, which is a VOP, of course, and the 2004 CF 2784, which is a VOP. As to, at this time, he would withdraw his previously entered plea of not guilty, tender plea of no contest. On the new law violation, he'd be adjudicated guilty, 10 months Okaloosa County Jail with credit 4 times served, and the state and I stipulate that he's already served the 10 months, $665 in court costs. As to the two VOP cases, Judge, he would admit, reinstate to complete original terms and conditions, and is stipulated by the state and defense that GPS is not required or ordered on either of the 3 sentences. May I approach, Judge?
All right, Mr. Canfield, would you raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, sir.
State of Florida versus William Riley Canfield, Jr., 23 CF 2442, 2005 CF,
I might have written CF twice there, Judge, sorry.
is it 1020,
9,
1029?
correct.
And 2004 CF 2784. So you want to enter a no contest plea to, in 23 CF 2442, failure to report vehicle within 48 hours, a third-degree felony, and admit that you violated probation in the other 2 cases, correct?
Yes, sir, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir, Your Honor.
Are you under the influence of any drugs or medication that prevents you from knowing what you're doing here today?
I'm not under any influence, and I know what I'm doing, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you happy with the work Mr. Shaw has done for you on your case?
I am, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it. 23 CF 2442, adjudicated guilty since the 10 months Okaloosa County Jail with credit for time served. State stipulates that he's already served his 10 months, $665 court costs. In 2005 CF 1029 and 2004 CF 2784. Reinstate and complete the original terms and conditions of probation. GPS not required.
Or ordered.
Not ordered or, what does this say?
Not required or ordered, Judge.
All right. On any of these cases, standard court costs on the VOPs. Is there anything else?
That's it, Judge.
Do I adjudicate him? Yeah, adjudicate guilty. And on all cases, all counts. Okay?
Thank you, Judge. That's all I have.
Now we got, do we have Daniel Wesson and Patrick Medina?
We've also got David Stanley we held over from this morning.
No, he didn't have an attorney at this point. It was no attorney.
Where is he?
I've got him right here.
The state was gonna look to see what his offer was. Yeah.
No, me.
Oh, it's him. He was, yeah. No, I know.
Whoever.
Yeah, yeah.
Whatever was going on.
Give me a second.
All right, is this David Stanley?
Yes, sir.
Yeah.
What are we doing on
The
Mr.
state's
Stanley?
gonna ask what probation recommends as their offer on Stanley David. David Stanley.
20 CF 24.
Yeah.
Ms. Rivers, what was that case number?
20 CF 2443.
20 CF 2443. Charged with?
Violation of probation.
Keep going down.
Oh, down.
Trying to work out something for you.
Yes, sir. I appreciate it.
Courtroom sounds like the new game of silent tennis, you know, same as regular tennis, but without the racket.
We're gonna get it settled.
All right.
The state would be willing to revoke and terminate for 30 days in county jail.
Credit for time
Right
served.
after time served. I don't know how much time he has.
How much time you got?
220 something to 8 days.
Probably got it covered.
Sounds good. But that's still the state's offer.
Would you raise your right hand and be sworn? You swear the testimony you give for this court's true, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge you guilty. Sentence you to, what is it, 30 days? County
30
jail.
days, yes, sir.
County, 30 days county jail. Credit for time served.
Thank you, sir.
Okay?
Revoke and terminate.
Revoke and terminate. Okay? Court orders you not to break the law in the future.
Yes, sir. Thank you so much.
Outstanding monies to collection,
Yep.
and I'll get a score sheet.
All right.
Got Weston and the other one right there. I don't know.
Medina.
Wesson and Medina.
That one.
Where are we at on Wesson? Is he out?
No, we both have custody.
What's the, we got a motion hearing on Mr. Wesson, 24 CF 783.
Yes, Your Honor, filed a motion for new trial. Yes.
Is this the aggravated on the law enforcement officer?
Yes, Your Honor, it is the trial we had.
Go ahead and argue your motion.
Yes, sir.
All right.
Would you rather just go back to the, okay.
Is he not, Mr. Wesson not feeling good?
Your Honor, he's not. He's been having complications in regards, I guess, to the colostomy bag.
Yeah.
And they won't.
Let's let Mr. Wesson, do you want to go back?
No, I'm gonna go ahead. You can go ahead.
Go ahead. You want to sit down? Why don't you have a seat? Okay, go ahead.
All right. Your Honor, we're here today on our motion for a new trial. If the court will recall, back on July 9th, we had a jury trial on his charge of aggravated battery on law enforcement officer. The court, the jury, I should say, found him guilty as charged. Mr. Wesson's rights, it is our argument that they were violated, and he seeks a new trial based on several grounds. One of which is during the course of the trial, investigator Aaron Pittman testified about Mr. Wesson being on probation or mentioned his probation officer, and he talked about him wanting to go to a program rather than going to prison or going back to prison. And this was improper character evidence under 90.404 and 90.610. We objected, and the court gave a curative instruction. We just believe that you can't unring the bell in this situation. This improperly brought out his criminal history, and we believe that the court should have granted a new trial at that point, did a mistrial and granted a new trial. The others, Your Honor, that I also cited are ones that I had cited before during the trial. In regards to Mr. Wesson, the state sought to introduce and did introduce his violation of probation warrant, the paperwork which showed that he, in fact, had a case and that he had violent tendencies. We believe that this was improper, that if the state had wanted to try to introduce it, they should have done it under Williams' rule, followed the procedures under Williams' rule, and they did not, so we believe that it shouldn't have come in. Also, and that's if the court believed that it should come in. We believe that it shouldn't have come in because that its probative value, if it was relevant, was substantially outweighed by the unfair prejudice in that particular charge and in that particular situation. So we believe that it denied him his opportunity for a fair trial. We're asking the court to reconsider and to set aside the jury's verdict and to grant him a new trial.
Your Honor, first, I'm going to address the issue. I'm going to go by the motion. First of all, the state that did not, throughout the trial, speak about the violence tendency. Second, Williams' rule does not apply because there is no mention of actual similar acts or crimes. Additionally, the violation of probation warrant had to be introduced and admitted because it was one of the elements that I had to prove that they were there for a legal duty. They weren't there just because they wanted the law enforcement. They wanted to be there. Additionally, the court ruled in favor of the defendant and ordered me to redact any wording that said probation on it. The fact that there was a prior use of violence. See, Your Honor, that was redacted. It wasn't shown to the jury. The only thing that was left there was the history of violence. The reason for that, we had arguments. I brought up a case, Wilchcombe v. State. The court, the third DCA, ruled that kind of evidence is admissible in an aggravated assault or aggravated battery because unless it's precluded by some specific exception or rule of exclusion, and there is nothing specific. It wasn't hearsay because it was intended to be introduced to show the effect that that information had on the victims being analyzed by the jury according to a reasonable person standard. Now, it's also the state's position that, first, according to 90.403, the court has broad discretion in the admission of evidence and in determining whether its probative value outweighs any prejudicial effect. We shouldn't forget about the overwhelming evidence that the state produced at trial, where the jury was able to see with their own eyes the crime that this defendant was committing. They were able to see that he had a knife in his hand. And as far as I'm going to address now Investigator Pittman's comment about probation, He was instructed by the state, according to the court's ruling, that there was no probation to be mentioned. However, as he was caught talking, he was just reporting what the defendant stated to him. There was a prompt objection made by the defense, and the judge correctly instructed the jury to disregard that comment. What else? I'm not sure if defense mentioned it in her argument. The last point that they're writing in their motion is that the state during direct and closing spoke about the officers having family and kids. Again, that's not prejudicial at all. It was just intended by the state to show that the reasonable person standard. They're people like everybody else with family and kids. It wasn't to cause any unfair prejudice to this defendant. I believe based on the objection and arguments at trial and the arguments today, the motion should be denied.
Anything else?
Your Honor, only to reiterate, since the state brought it up, this defense was willing to stipulate to the fact that they were there for a lawful reason. There was no need to introduce the violation of probation warrant. That was just something that the state insisted on, and the court agreed. We believe that that was, again, we maintain the same position on that. As for the last argument, at no point did asking questions about the officers' kids and their feelings and things such as that have anything to do with the elements of the crime. The state elicited that to play on the sympathy of the jurors, and we believe that that should not be appropriate.
Motion is respectfully denied.
Thank you, Your Honor.
Next. We got Patrick Medina.
Yes, sir, that's mine. Judge, this is, well, let's let him get out here. Judge, this is Patrick Medina. Mr. Medina was referred to and accepted into drug court. Unfortunately, after he was accepted in drug court, he developed transportation issues. He still wasn't out of jail yet. They had just taken the plea, and he found out that he wasn't going to be able to have access to the living space of the car. And so drug court allowed him to withdraw his plea, and that put him back over here. Mr. Sprouse, I think, wants to go ahead and just have a VOP hearing so that at least the guilt or innocence of the VOP is resolved. I'm still, the recommendation of probation was a inpatient drug treatment program, and I'm still trying to get him in someplace.
That's correct. We should have the VOP hearing. If the defense wants to plead straight up to the bench, they can. I'm asking for DOC.
He scores, I want to say, 27 months and change, and that's what the state's asking for.
How much time has he got served already?
Mr. Medina's been in and out of jail on these cases for a while. I had him in the very beginning and then had to withdraw because I think we were representing Stephanie, his wife. So I'm not sure whether he bonded out at some point. But how much time do you think you have in total on this?
Close to a year.
What is the allegations of the VOP?
They found a straw with suspected fentanyl residue. He's alleged to have made a statement to the officer that he had gotten rid of the fentanyl some 2 hours earlier. I don't know that he ever had an actual possession of paraphernalia charge brought, though.
Is it just a VOP, not any new charges?
There was a new charge. It was a misdemeanor charge.
He did get charged with possession of paraphernalia?
Yeah. Okay. That's the one that he entered into a plea, and he was allowed to revoke it.
Oh, was that part of the drug court?
Mm-hmm.
Okay, all right, so that's still pending then.
It's not still pending. They allowed him to withdraw the plea. That's my understanding. There's no documentation about the withdrawal, but it was a contest plea.
What do y'all want to enter y'all want a hearing or you want to enter a plea, I guess is where we're at.
Judge, I want to try to either get him in a program or get him out. I don't want him to go down to DOC. You know, given that drug court was willing to take him and he was willing to do drug court, nobody wants him to be set up for failure. And the probation's recommendation is a program. I would enter a plea if that were on the table, but it's not on the table.
It's his third violation of probation, Judge. So he's not amenable to following the rules of probation. DOC is proper. He scores DOC.
All right, well, are we ready to have a hearing then?
The state's ready.
Judge, he's indicated to me he's willing to just go ahead and, based on the conversation that we've had here, just enter a plea straight up to the court, and then I'll argue for putting off sentencing for me to get him into a program. And if the court doesn't feel like that's appropriate, or if the court's looking at something more along the lines of county jail, then the court could just deny that request and do so. I would ask the court, let me try to get him into a program before you send him downstate. That's all.
Well, I'm not going to commit to anything until I hear y'all's.
I understand, Judge. I understand.
All right, well, Mr. Medina, you want to enter an admission to the violation of probation?
Yes, sir.
Would you raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
Sir.
Are you under the influence of any drugs or medication that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Absolutely.
You know there's no plea agreement that I can sentence you to. They're asking possibly for, 27 months prison, or your attorney wants some type of drug program or anywhere in between, something like, I can give you whatever I think is legal. You understand that?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. And how much time y'all want for bring you back for sentencing?
Judge, the paperwork, let me inquire. The paperwork should have gotten back to our office shortly after the 13th of this month. I'll have Dave check on it, but I would anticipate we'd have some kind of response within, because I think we're only primarily looking at two different facilities, Keaton and Phoenix House. So I would think we'd have a decision within a month.
Well, Judge, can't we sentence him to DOC, and any inpatient treatment that he receives counts as incarcerative?
Well, I mean,
I'm
he's
concerned he'll get transported.
he's sitting in jail right now.
Mhm.
So, I'd like to give him a chance to see if there's some program.
Thank you.
Might give him
Well-
Department of Corrections, I don't know. I just have to see what's available and what he's done and how he's behaved in jail and what his record is, and, you know. I gave him 24 months in DOC, that might be less time than I gave him county jail time. I mean, with the gain time, that kind of stuff. I don't know. But I'd like to first see if he can get into some kind of program.
Judge, I doubt seriously we'd have a result by the 5th. And I think the next miscellaneous day is September 26th.
Yeah, I'll
and that
take a
would
look
be
at it
roughly a
September
month.
26th. I can give him, what, 27 months? Is that what you said, DOC?
That's the guidelines sentence, Judge.
I
It's
told him I can
27.
give him 27 months, or I can give him some program, or give him whatever I think is legal.
The score sheet that I have is 29 and change, but the state would be willing to downward depart for the 27.
I'd rather see him have the opportunity rather than haggle over 2
Well,
months.
You know,
This is the
I
third
could give him a
DOT.
suspended sentence, I guess, I couldn't I?
You could, Judge,
Any
but
of the above would be a legal sentence, Judge.
I might give him, I don't know what I'm gonna give him.
Yes, sir.
I'll have to think about it. I'll listen to you. I'll listen to, you know.
Thank you,
Was
Judge.
his violation any type of
It wasn't violence,
Violence?
Judge. It
Violence?
was, he was in a vehicle and he was found with paraphernalia, drug paraphernalia, and he admitted that he got rid of the actual controlled substance.
He's pled.
Before.
I'll look at it September 26th.
Thank you, Judge.
This gentleman back here, you came out, what's your name? Walker?
Judge, this is Mr. Little Walcott. He was supposed to be in court on the 26th. He said that I told him that he wouldn't need to be there unless I called him. I suspect that he misunderstood me. I was thinking about doing written motions to continue, and what I tell people is be in court unless I tell you otherwise.
Did I issue some type of capias for him?
You probably did, Judge. I don't have the file with me. I got a call from my secretary that he was at the office maybe half an hour ago.
What's your name, Mr. Walcott?
Little Walcott.
Little dash Walcott.
Little
is a
dash.
hyphenated name.
Oh, I got you. Okay. Okay, what day is he supposed to be here?
10/28. He's on the main trial docket. We've been trying to get evidence from a Ring camera, and Google, who runs Ring camera, is suggesting that we perform an anatomically impossible act. So I may have to see what I can do in terms of a contempt on it.
I have no idea what you just said. I'll,
It's a tech company, Judge. They're difficult for all of us to work with.
I would draw
They're like for-
the capias, so I'm not going to put you in jail, but be in court October 28th, okay?
Yes, sir.
Be at 9 o'clock, correct?
Make sure you get with Mr. Williams before then to work on your case.
He's been good about meeting with me, Judge.
All right.
I've probably met with him 3 times already.
October 28th then, okay?
Yes, Your Honor. I
Thank you.
appreciate it.
Okay.
Thank you, Judge.
Withdraw the capias.
Can I just drop your name next to the email I have?
What's next? Is that it? Okay. Oh, I thought I said the 26th, didn't I?
October 28th.
I thought I said September 26th on Medina.